Hello everyone, welcome to HW News. My name is Aarti. 20 months since he was arrested, JNU student Sharjeel Imam still remains behind bars without any bail. Sharjeel Imam, a JNU PhD scholar, was arrested by the Delhi police in January 2020 for his speech at a CAA protest in December 2019, the clip of which went viral on social media. Now, according to the police, he was allegedly instigating people to cut Assam off India in the speech. Imam had allegedly said that if 5 lakh people came together, they could cut northeast of India. A few days after the video went viral, Imam was arrested from his hometown Jehanabad in Bihar. Imam has since clarified that he was not speaking about cutting Assam off India, but he was instead speaking of a road blockade, a chakka jam. However, he has been in police custody since January 2020. On Friday, a Delhi court dismissed the regular bail plea filed by Sharjeel Imam in a 2019 case alleging that he delivered provocative speeches which led to Delhi riots at various places, observing that the tone and tenor of the incendiary speech tend to have a debilitating effect upon the public tranquility, peace and harmony of the society. However, in the same order, the judge also noted that the evidence to support the police theory that the rioters got instigated by Sharjeel Imam's speech, indulging in the acts of rioting, mischief, attacking the police party, etc., was scanty and sketchy. Thus, the court order has left many puzzled. Let us discuss this in today's video, but before that, HW News Network is striving to bring you stories, analysis and explainers on topics that are rarely talked about in the mainstream media. The story behind the story. But to continue doing that, we require your support. So viewers, if you like the work that we do, the videos that we bring, please do subscribe to us. Go to www.hwnews.in, click on the support on the topmost toolbar and select the plan that you want to take up. You can opt for monthly one-time payment as well as yearly one-time payment. Your support will ensure we thrive and continue to bring you better and better stories. Now, coming back to Sharjeel Imam's denial of bail. First, let us understand what are the charges on Sharjeel Imam. Now, Sharjeel Imam has various cases against him, including under the stringent Unlawful Activities Prevention Act, that is UAPA, in 5 states, that is Assam, Uttar Pradesh, Manipur, Arunachal Pradesh and Delhi. On 25th of January 2020, Assam Police became the first to register an FIR under the anti-terror law and various other IPC sections. On the same day, Uttar Pradesh's Aligarh Police booked him for sedition and creating enmity between different religious groups. And the trend continued with Manipur as well, where he was charged under several IPC sections, including sedition, that is 124A, but not the UAPA. The very next day, on the occasion of Republic Day, the Arunachal Pradesh Police registered a case of sedition against him. The Delhi Crime Branch followed the suit by registering an FIR under IPC section 153, which is wantonly giving provocation with intent to cause riot, along with charges of sedition and promoting religious enmity. Most activists who were charged with inciting riots or conspiring for the Delhi riots have been booked under both UAPA and sedition. However, Sharjeel Imam faces not only these draconian laws but also several other charges in not 1 or 2 but 5 different states. Now, Additional Sessions Judge Anuj Agrawal, while denying bail to Sharjeel Imam, noted that the issue whether the speech would fall within the ambit of section 124A of the IPC, that is sedition or not, required a deeper analysis at an appropriate stage. However, it said that a cursory and plain reading of the speech reveals that same is clearly on communal or divisive lines. The judge said, and I quote, "In my view, the tone and tenor of the incendiary speech tend to have a debilitating effect upon the public tranquility, peace and harmony of the society. Therefore, in the facts and circumstances of the present case, and considering the contents of the speech which tend to have a debilitating effect on the communal peace and harmony, I am not inclined to grant bail to applicant Sharjeel Imam at this stage." Now, on December 15, 2019, an information was received by police regarding demonstration against the Citizenship Amendment Bill by the students and residents of Jamia Nagar. It was alleged that a mob had blocked traffic movement on the road and started damaging public and private properties and vehicles with sticks, stones and bricks. It was alleged that it was his speech, that is Sharjeel Imam's speech, which instigated a particular religious community against the government by creating fear in their minds regarding CAB and NRC. Now, as per the prosecution, the said speeches delivered by Sharjeel Imam were seditious, communal and divisive in nature and were aimed at promoting enmity between different religion groups. Now, the court remarked that while the Constitution guarantees us freedom of expression and speech under Article 19, it must be remembered that it also puts reasonable restrictions on the said right on the grounds of public order and incitement of offence. The judge also quoted Swami Vivekananda while denying him bail. Interestingly, he said, and I quote, "We are what our thoughts have made us. So take care about what you think. Words are secondary, thoughts live, they travel far." While the court rejected bail to Sharjeel Imam, saying that the tone and tenor of his speech was incendiary, it also noted that the police theory in the case that the rioters got instigated due to Sharjeel Imam's speech lacks evidence. He said, and I quote, "Neither any eyewitness has been cited by the prosecution, nor there is any other evidence on record to suggest that co-accused got instigated and committed the alleged act of rioting upon hearing the speech of the accused Sharjeel Imam. Further, there is no evidence corroborating the version of the prosecution that alleged rioters were a part of the audience addressed by accused Sharjeel Imam on the day of the speech." Now, this is what the judge noted in paragraph 10 of his order. Continuing further, he said, upon specific inquiry by this court, special public prosecutor fairly conceded that at this stage there is no material available with the prosecution to the effect that accused and other co-accused persons were members of any common social platform, that is WhatsApp, etc., so as to fasten the liability of acts of co-accused upon present applicant with aid of section 109 of the IPC. The essential link between the speech and the subsequent acts of co-accused is conspicuously missing in the instant case. He further said, and I quote, "The theory as propounded by investigating agency leaves gaping holes which leaves an incomplete picture unless the gaps are filled by resorting to surmises and conjectures or by essentially relying upon the disclosure statement of the accused Sharjeel Imam and co-accused. In either case, it is not legally permissible to build the edifice of the prosecution version upon the foundation of imagination or upon inadmissible confession before a police officer. Once the legally impermissible foundation of imaginative thinking and disclosure statement of accused are removed, the prosecution version on this count appears to be crumbling like a house of cards." Though Special Public Prosecutor argued that said disclosure statements are relevant under Section 8 of the Indian Evidence Act, however, the said argument appears to be nothing but a desperate attempt on his part to save the day for the prosecution. Now, on October 4th, Imam had told Additional Sessions Judge Amitabh Rawat during a bail hearing that he was not a terrorist and that his prosecution was a whip of a monarch rather than a government established by law. Advocate Tanveer Ahmed Mir, representing Imam, had told the court that being critical of the government could not be a cause of sedition and that it was a duty of every citizen to be critical of the government. He charged that there were many prosecutions against Imam just because he had criticized the government's policies. Now, it must be noted here that the court's observation do raise some important questions about the police investigation into the whole matter. While the police claims it is Sharjeel Imam's speech that instigated the riots, it fails to provide any statement by those accused of rioting saying that they were in fact instigated by Sharjeel Imam's speech. There is no eyewitness to that effect, that the police failed to establish any corroboration between them, and it also failed to establish whether the accused and Sharjeel Imam were connected with a common link like social media platforms. Thus, the court also noted that once these claims of prosecution, which are based on impermissible foundations like imaginative thinking and disclosure statement of the accused, there is nothing left in the case. Do let us know what you think about this in the comment box below. For more news and updates, you can log on to www.hwnews.in. Also, before I end this video, if you like the videos that we make, please do subscribe to our channel. It helps us grow our community. Please do like this video, comment below it, and if you're watching this video on Facebook, please do like our page and share this video to as many people as possible. Thank you so much.